Good afternoon, and welcome to our panel discussion, Justice in the Time of COVID-19, Strategic Responses. Today's panel is being hosted by AEquitas. My name is Holly Furman. I'm a Senior Associate Attorney Advisor at AEquitas, and I will be introducing today's moderators. There will be a few polls throughout today's panel discussion, and we encourage you to participate in each poll as it arises. If you have a question during the discussion, please enter it in the chat box. We will answer questions at the end of the panel if time permits. You are also welcome to contact us directly at any time following today's discussion, and we will send you contact information during our follow-up. AEquitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, AEquitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on AEquitas, please visit our website at equitasresource.org. You can also follow AEquitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's panel discussion is supported by the U.S. Department of Justice Office of Violence Against Women. The information presented in this panel does not necessarily reflect the views of OVW. Our moderators today will be John Kurland and Patty Powers. Currently an attorney advisor with AEquitas, John Kurland worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, serving as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. Throughout his career, John has successfully prosecuted a variety of offenses, including domestic violence homicide, campus sexual assault, cold case sexual assault, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. Patty Powers joined AEquitas as an attorney advisor after serving as a senior deputy prosecuting attorney in Washington State for 27 years. During her tenure as a prosecutor, Patty supervised the sexual assault domestic violence unit in her office. She frequently and successfully prosecuted sexual assault, domestic violence, child abuse, and related homicides, which included complex litigation of high-profile cold and current cases. For 5 years, Patty served as a highly qualified expert for the United States Army Central Intelligence Command, through which she consulted and provided specialized training on military sexual assault and domestic violence. I will now turn it over to John and Patty.
Afternoon, and one of the challenges of having limited time in such an illustrious panel is that it's challenging to condense their biography, something doing justice to their background and experience. But what we offer is at least an abbreviated version of our panelists' background and biography. DA Sherry Boston has been District Attorney for DeKalb County, Georgia since 2017. She is one of only 3 African-American female district attorneys in the state of Georgia, and among the rare 1% of African-American females currently serving as district attorney nationwide. She was recently lauded by Atlanta Magazine as one of Metro Atlanta's 500 most influential people. DA Boston is the only district attorney appointed to the newly formed Grace Commission, a statewide task force created by Georgia's First Lady to combat human trafficking. In addition to her elected positions, DA Boston has received numerous legal appointments and wide recognition for her prevention, intervention initiatives, and impassioned commitment to domestic violence awareness. In 2018, she received the Champion for Change Award from the Women's Resource Center to End Domestic Violence for her leadership in the DV arena, including the development of 2 signature community awareness campaigns.
I'm Patty Powers. Good afternoon. I'm Patty Powers, and I'm honored to join with John in moderating this panel. We next make an introduction of District Attorney Nancy E. O'Malley. She has served as the Chief Law Enforcement Officer in Alameda County since being appointed by the Alameda County Board of Supervisors in September of 2009. Subsequently, she was elected to this position in November of 2010, 2014, and 2018. District Attorney O'Malley is a nationally recognized expert in issues involving violence against women, violence against persons with disabilities, and interpersonal violence, including sexual assault, domestic violence, elder abuse, child abuse, stalking, and human exploitation and trafficking. She is the first woman to serve as Alameda County's elected district attorney and is a leader known throughout California and the country for her innovation and vision. District Attorney O'Malley's professional accomplishments include monumental contributions in the legislative arena, with numerous bills written by District Attorney O'Malley having signed into law. She has participated in drafting legislation that has included making courtrooms around the state accessible for victims with physical and intellectual disabilities, ensuring that sexual assault victims have rights in the criminal justice system, and also expanding the support available to victims of crime in California. District Attorney O'Malley is also a member of the AEquitas Board of Directors.
We are also very fortunate and grateful to have with us this afternoon First Assistant District Attorney Ed McCann Jr. from the Montgomery County District Attorney's Office in Pennsylvania. Ed McCann has served as the First Assistant District Attorney for the Montgomery County DA's office since he joined the office in February of 2016. Prior to that, he served for 26 years in the Philadelphia District Attorney's Office, with the last 4 as the First Assistant District Attorney. In that position, he oversaw a staff of 300 attorneys and 200 support staff, managed the annual budget, oversaw human resources, and worked with city administration, police officials, and other law enforcement agencies. McCann also served in the Philadelphia DA's office as the Deputy of the Trial Division, Chief of the Homicide Unit, and Chief of the Felony Waiver Unit. He was an Assistant District Attorney in the Law and Trial Division from when he joined the office in 1989 until 1998. First Assistant McCann is a frequent speaker and educator, conducting national trainings for prosecutors, law enforcement, and social workers in the investigation and prosecution of cases of physical abuse of children and domestic violence. He is also a frequent instructor on mental health defenses and homicide investigation and prosecution. And we are grateful to all our panel for participating in this discussion today and hearing from them about how they've been confronting and dealing with some of the issues of the COVID-19 pandemic in their communities from across the country. And for the first issue, I will hand it off to my colleague, Patty Powers.
Thank you very much, John. As we all know, COVID-19 has added a strong dimension of urgency to our consideration of impact on our communities, as well as our response as criminal justice professionals. This is our first question that we're going to be addressing to each member of our very distinguished panel. What has been the greatest impact of COVID-19 in your community's handling of sexual violence, intimate partner violence, stalking, human trafficking, and other violent crimes? We'll begin with District Attorney Boston. Could you please address this question and tell us about the challenges in your community and how you're working to resolve these issues?
So thank you so much for having me today. And I'm glad to be a part of this distinguished panel to discuss very challenging times in our community. What we've noticed in my jurisdiction, primarily in these particular issues around sexual violence and intimate partner violence, is a lack of reporting medical issues and seeking medical treatment after assault for fear of contracting COVID-19. We are finding that victims are hesitant, as probably all of us are, to go to hospitals or emergency rooms. We're also finding that getting victims to leave during these times is also a challenge because safety planning can be a little bit more challenging when those of us that are under, many of us are under stay in shelter orders. So there is a very limited place to go as far as being able to escape to family or friends. And there is this fear of leaving their residence, not knowing where to go. We've also found a decrease in victim disclosure and the ability to identify victims. The concern is that victims' lack of social interaction with their community, whether it's at work or at church, particularly in schools for our children, it makes it a little bit harder to identify and disclose physical, sexual, and intimate partner abuse. Common interactions with the world has always kind of been a place for our victims to be able to make those outcries. And some of the ways that we are trying to respond is safety planning geared towards technology, the use of mobile devices and social media, and making those appropriate referrals. It's so important right now for us to continue letting people know how we are still working, that despite the fact that it seems like the world is closed, that the service providers and law enforcement are still available. We are working with our victims to let them know that with a shelter-in-place order, we need to be strategic about what we can do. And also making sure that our victims know that our courts are still operating for these emergency services, such as temporary protective orders, that they're still in place. And that orders that they had before perhaps judicial emergencies in many areas have been extended, despite the fact that they have not had permanent hearings. It's important to coordinate with the law enforcement partners to make sure that our uniformed officers on the ground understand what services are out there and can point our victims in the directions they need for help. And also when it comes to forensic interviews or SANE examinations, we want to make sure that our community is aware that there's other locations outside of hospitals that we provide those services. So whether it's your local family protection center or some other location where COVID-19 patients are not being treated, we want to make sure that our community knows about other locations that they can get those types of physical examinations for purposes of their protection.
Thank you so much, District Attorney Boston. And we'll turn now to District Attorney O'Malley. Could you also focus on what has been the greatest impact of COVID-19 on the work that we're committed to and how you're responding?
Yes, thank you. And also, I'm very proud and happy to be here with all of you today. I would echo a lot of what DA Boston has just said. There, in my county, in my state, this is California, that we have not seen a dramatic drop in reports of sexual assault or human trafficking cases, at least in my county. And we're a very active county in prosecuting human trafficking cases. What we are seeing is a drop in reports in domestic violence, and it's understandable, and we believe this to be the case because people are confined to home, as with most of the states, if not all. And it's there's no opportunity to be able to get in a private area to make the report for many. We have been working with the hospitals to make sure that when somebody does come into the hospital for a non-COVID-19 issue, specifically for sexual assault or domestic violence, that they are in contact with us as well. Our human trafficking situation and how is become, I will say, depressing and disappointing, because we still have in many parts of the cities young women on the street being trafficked, sex trafficked. And just the other night, there was an operation where 3 girls were separated, but they refused assistance, and the police didn't have any place to take them anyway. We have also seen a huge increase in the ads on the internet, and just in Oakland alone, in the last 24 hours, there were 824 ads that were advertising for young women to be sold for sex. It's very difficult in this time to do righteous investigations of all of these crimes. We've had to send some investigations back because they're just not complete. We have seen a drop in, like I said, the domestic violence reporting, but in the last 3 days, we've had two domestic violence homicides. So we are being more proactive about what we can do. The police are responding and they're investigating, but they are told to avoid close contact, stay beyond 6 feet, and to avoid their own exposure. And as a matter of fact, in one of the special victims unit, the entire unit was quarantined due to one of the officers being testing positive for the virus. So we're relying on officers that have not been specially trained to deal with domestic violence, sexual assault, stalking, human trafficking. And that means that we need to help them even more so. What we also have found is that the rape crisis advocates are not going to the hospital with the victim survivors. The rape crisis centers have tried to do it telephonically or through some iPads or other technology, but it just is not the same. And in fact, the law enforcement is very delayed in reporting to the hospital when a sexual assault victim comes in or a domestic violence person comes in, and we've had victims, the hospitals have reported back to us that victims have left. And then lastly, our child interviews, again, the most vulnerable people who have no exposure to the outside world. Those child interviews have been halted due to the issues around safety precautions and distance and things like that. So what we are doing is that we have a family justice center, which is open for emergency and crisis cases. I believe all of our shelters and all of our service providers for DB and sexual assault are only using phone, but we are open for those cases. And we are a resource now for helping people figure out where they can get help and what help they need, even with the skeleton crew at the Justice Center. We're still helping people get restraining orders through the phone and through video technology with our courts. And all of our courts have extended automatically any restraining order or other protective order that's in place. We are putting out a lot of public service announcements. We're using social media, we're doing video messaging, we're even considering radio and television ads to remind people that are sheltering in place that there are, to be aware of these dangers, and also if it's happening to any of them, that there are resources that are available to them so that we can help continue to give our community, and particularly the victims and those that are witnessing this, the ability to make their reports and know that they can be safe. The other thing that we are doing is that while the district attorneys, the victim advocates, and our investigators are pretty much working remotely, they are actually getting more involved in these cases at the time of report to be able to help these less experienced officers to do an investigation that we can move forward with. We do have the ability still to relocate people and to provide resources from them. And while there are challenges with that, at least we do have the ability to get people out of a dangerous environment and into a place where they can be safe and protected. And then lastly, we're calling every victim that we have that we've been working with over the last several months to see how they are doing now and if they need anything from us now. So with that outreach, we're really finding that people are feeling very vulnerable, but responding back to us that they appreciate that someone is paying attention, someone is checking in with them.
Thank you so much, District Attorney O'Malley. And now we turn to First Assistant District Attorney McCann. Could you please direct your attention to this question and talk about the greatest impact of COVID-19 in your community's handling of these cases that are so important to all of us, as well as the process that you're using to respond?
Just to give you a little bit of an idea of what Montgomery County looks like, we are the third largest county in the state behind Allegheny and Philadelphia County. We have about 825,000 people, but it's a really diverse county in terms of the type of areas that we service. We have urban areas. We also have traditional suburban areas and also some pretty rural areas. So it runs the gamut. I would say there's probably two biggest problems that we've faced up to this point, and a lot of our issues are the same as DA Boston and DA O'Malley just said, but I want to focus on what I see as our two biggest problems. First would be the issue of serving domestic violence victims in the protection from abuse order process. The current process, I don't think, serves their needs as far as the support and guidance that they had been getting prior to the COVID-19 pandemic. We have an excellent advocacy center in Montgomery County called Laurel House for our domestic violence victims, and they traditionally are able to sort of walk the victims through the PFA process, and that's been interfered with, and in fact, just about halted in the traditional sense right now because of the pandemic, and we were probably the first county that got significantly affected by it in Pennsylvania. Our courthouse has been really restricted in terms of who can come in, and there's only 2 courtrooms open right now for emergency filings. One does criminal and juvenile, one does civil, family and orphans court, and the civil court would include the protection from abuse orders. So to this point, the advocates have not been permitted into the courthouse to help walk the victims through the process, and they're sort of on their own. As I said, Laurel House is excellent, and they're usually present to help the victims through this process, and that's not going on right now. They're trying to help the best they can with helping the victims fill the paperwork out before they come to the courthouse, and they're also been available on FaceTime as the victims go through the procedure, but that's clearly not ideal, and I have some real concerns about that issue. The second would be similar to what both DA Boston and DA O'Malley said, and that would be the investigative impact. The limitations and, in fact, the inability in certain circumstances to conduct the type of interviews that you need to conduct in person in order to really do a good investigation in these cases. I'm going to talk about that more in the next section when I discuss the impact on arrest and charging decisions. But that is a very big issue. And I think both DA O'Malley and DA Boston said important things when they talked about making sure the message goes out that we're still working, and that folks know that they can still rely on us, and that we're still available to help them. That's important, and we're doing our best to do that. The same through releases and trying to get out on social media the fact that victims in these situations can still turn to us if they are if they're in trouble, and that they can still get help even though the courthouse is basically closed to everything other than emergency filings.
Thank you so much, Chief Assistant McCann. And for those of you that are with us today, we're now turning to our first participant poll. We'd like to ask you to please consider and respond to this question that you now see on the screen. What has been the greatest impact of COVID-19 in your own community's handling of sexual violence, intimate partner violence, stalking, human trafficking, and other violent crimes? And you're going to be given 5 different alternatives to consider for your response, as you will see. We're talking in number 1 about the impact of concerns regarding population reduction on arrest warrants and bail decisions. In other words, the concerns of local jails or departments of correction with population reduction, and how that may impact arrest or seeking an arrest warrant or making a decision on bail. Second, the impact of delay in and of itself on investigations, the contacting of witnesses, the testing of forensic evidence, and also the impact of delay on charging or issuing indictments. Third, the impact of court-ordered delay of trial proceedings and the prospect or concern for future motions to dismiss based upon a violation of speedy trial. Next, the impact of court order delay on victims who may be facing indefinite timelines for the resolution of their case or the potential of trial. And finally, the alternative of impact on your ability as criminal justice professionals to collaborate with other professionals to develop practices and policies responsive to victims of violent crimes in the wake of COVID-19.
And hi, this is John Curlin here. I'm going to wait for my colleague Holly Furman. As soon as an opportunity is expired for that poll to be administered, I'll advance to the next issue.
Yeah, so we have, most people are saying that it's impacting the delay in investigation and charging.
All right. Then I will move on to the next issue and we can revisit it later. Well, drilling down on some of the challenges that have been raised by our panel, we want to explore their perspective and get a little bit about the approach in their communities and with their offices about how they're balancing the public health risks, public health issues with victim and community safety. And by these trade-offs, what we're meaning is the social distancing and lockdown recommendations to protect public health. How can that be balanced, or how can you attempt to balance that with victim and community safety, especially when we're considering which offenders to arrest or not to arrest, which cases to develop as fulsomely as we would have in non-pandemic times, how we balance prison population and the safety of prison population issues with the safety of both the individual victims of sexual violence, domestic violence, human trafficking, and with the victims and with the community at large. And I'm going to address a particular aspect of this balance question first. First Assistant McCann, who alluded to it in his earlier answer. And the question I'd put to you, First Assistant McCann, if you could share with our audience, in Montgomery County, how has the pandemic impacted law enforcement's arrest decisions, especially in domestic violence, sexual violence cases? How has it impacted your office advising and guiding those arrest decisions? If you could address that and talk about the approach, what has happened in your community or what hasn't happened in your community, and what approach you've all taken.
Sure. So I know some of the other panelists are going to talk in more detail on this issue, but John just referred to the whole issue of the prison population. And in Montgomery County, as I'm sure just about all of your jurisdictions, there's been a pretty significant endeavor to reduce the prison population due to the pandemic. And the population's down, over 15% in just a month. And that's an outgrowth of our policies anyway. The prison population's been down pretty significantly in Montgomery County the last 3 or 4 years, but that's still a pretty big hit within that period of time. And the president judge put out an order just reinforcing that judges have been instructed to minimize the number of defendants that would be held in custody. So that obviously is an overarching issue that we have to think about in arrest and charging decisions. Are we going to be able to keep victims safe if we charge a defendant in a particular case? Is it going to be a case that we're going to be permitted to have someone detained? There's a real, as I said, there's been a real push to get people out of jail. So to get someone in jail can be extremely difficult. So that's the overarching factor about charging the cases. Are we going to be in a position that we're going to be able to keep the victims safe? It's also hard, which I'll talk about towards the end of this particular section. Some of the non-monetary conditions of bail that we would normally rely on can be pretty difficult to enforce at this point. But just thinking about this issue, first of all, we have about 50 police departments in our jurisdiction, but most of them are operating under orders limiting their contact with the public, which is to only that which is necessary to public safety. So while they haven't been reluctant to collect evidence, and we've even approved search warrants during this time and in these types of cases, the main, I think, impact would be with respect to witness interviews. They're not really conducting in-person interviews at all. Some departments have been taking interviews via FaceTime and other electronic means, and we've been telling them that they're okay to proceed in this matter, if they have to. The problem with that can be, as all of us know, in domestic violence cases in particular, you can have situations where at a later time a victim is going to be uncooperative. So in Pennsylvania, the law is that if the statement is signed and adopted or recorded, you can use the statement at trial, even when the witness does not, assuming that the witness testifies, you can use it as substantive evidence in the case. But it's been really difficult for us to do the types of interviews that we normally would do in a case like this, with the possibility of a victim later deciding that they didn't really want to cooperate with the prosecution in a serious matter. As the DA O'Malley said, we're having the same issue with forensic interviews of children. We have discussed using teleforensic interviewing in appropriate cases. That hasn't happened as of yet, but that's something that we just discussed this past week. But obviously the delays in conducting interviews and collection of evidence has potential to create real issues. We're trying to take these on a case-by-case basis. There have been cases that we've decided to hold off on approving arrests and complaints, just in terms of being able to keep a victim safe, knowing that the facts don't merit detention, but that the victim would end up potentially being in a position where he or she would have to be in the same living situation as the person who victimized them. We are trying to work with the police really closely on those issues in terms of pulling the trigger on whether we're going to agree to arrest someone or not. The other issue I did discuss earlier is the non-monetary conditions of bail. Certain cases we might agree to someone to be released on stay-away order or things of that nature. That can be a lot more difficult to enforce at this point. As I said, the police are not really trying to have close contact with the public as much as they possibly can avoid it, so they might not be able to enforce the order as well as they could have before the pandemic. Also, we at sometimes would potentially ask for a psychological or psychiatric examination prior to a defendant's release on a case. It's really difficult to get that done right now, particularly in the prison, because the prison's locked down and not really letting people from the outside go into the prison to conduct these types of interviews. So basically what we're trying to do, as I said, is work with the police in terms of doing as much as they possibly can remotely, in terms of using audiovisual type of technology, FaceTime, Zoom, whatever, in terms of conducting interviews, really having probably a greater level of contact with them by the ADAs and our detectives in terms of victim safety on cases that we're about to charge, or on cases where potentially somebody could get out of jail. Really trying to have multiple levels of contact for them, so that they have an understanding that if something goes on, they can reach out to us. But really, the main thing I would say is that the main point we're trying to consider is, given this reluctance to add to the prison population, which is understandable, we're really focused on maintaining victim safety and making sure that if we do make a decision to charge somebody right now, that there's something in place to make sure that the victim remains safe.
Thank you, First Assistant McCann. I appreciate and really liked how you're thinking about in terms of teleforensic interviewing of children. You're anticipating or exploring options before the crisis arrives, so it won't be a first impression issue when that decision has to be made. D. O'Malley, let me ask you. I know best practice has been teaching us in cases of domestic violence and sexual violence and human trafficking that one of the things that we need to, as prosecutors, to make fully informed decisions and have the best cases is a fulsome investigation as possible, and to be working collaboratively with other disciplines to accomplish that. But how are you addressing when capacity of law enforcement is reduced, as you talked about a little bit in your initial answer, and capacity of medical providers is reduced? How are you adapting to this goal or ideal of having as fulsome investigations as possible with the reduced capacity available for our partners in law enforcement right now and medical providers? Could you talk about that, how the issues arisen in your community, and what accommodations you've made in circumstances that I don't think any of us anticipated?
Yes. So in my particular community, our SART center, our sexual assault response team, is actually hospital-based. And so the good news is that the staff is there, and they are trained special teams. They're trained to respond to sexual assault and domestic violence cases, as opposed to some other situations where many of the medical staff are furloughed and only the essential providers are there. So the first thing that we've done is we're in close contact with the SART team, the forensic examiners. And as I said earlier, that our rape crisis advocates are not appearing at the hospital with the victim survivors. But we are working through that with using medical social workers if they're available. No question the hospitals are really having challenges. And what we're now doing is exploring other places where the exams can occur, moving them out of the emergency room and maybe into one of the clinics that is not being used, which is really just a matter of moving some equipment around. In California, we have an electronic sexual assault exam form. So that's being done through technology already, where the exam and the findings are being recorded, and they are emailed to the law enforcement. We also have my office created a medical record chart, electronic chart called DVRR, which is Domestic Violence Reporting and Referral. And that also is a guide for medical providers who are doing domestic violence forensic exams. They can document, and also it has risk assessment tools. So we're very linked by using these two tools, we're linked very closely to the medical provider, local law enforcement, as well as victim advocates and our rape crisis and domestic violence providers. And as long as we have that opportunity to do it through technology, or by making phone calls, that we're able to make emergency arrangements. What we've been doing in California, many of the police agencies or the SART centers have been doing the forensic exam, but then taking 3 additional slides. They call it RADS, R-A-D-S. And the quick review of from the crime lab is to look at those 3 slides rather than the entire kit. Well, our crime labs have now determined that they don't want to send people into the hospital to pick up these 3 slides, that they would rather just have the kits delivered to them, which we are able to do. And that is for some of us, that we believe that's a good benefit, because there may be evidence that is located in the kit that is not going to be captured on one of the 3 slides. So we're working very closely with the crime lab to make sure that they are looking at the entire sexual assault forensic kit for either sexual assault or looking at any forensic evidence that is revealed through the exam at the hospital. It's been an important component of keeping in touch with the crime lab, because what's really important to all of us, I'm sure, and we'll talk a little bit later about this, is that we don't want to put on the back burner our ability to do forensic examinations, our ability to have the crime labs be testing the rape kits and the other forensic evidence that we have through medical exams. So we are keeping up with all of those components and keeping in very close contact with the people who are tasked with doing those follow-up exams. One of the challenges we have is that we're running out of kits, forensic sexual assault kits. So we're now scrambling to find more kits, and then we're actually purchasing them to make sure that there are a sufficient number in the hospital. The use of technology, as you heard just a few minutes ago, has been dramatically improved, that we can have conversations face-to-face through the computer. It's safe, and as long as we can provide a safe place for the victim or the witnesses to be able to engage with law enforcement or with the victim advocates from my office or the prosecutors, that we are shifting over to use of that type of technology and refining it to make sure it's the most effective that it can be. And as you know, as this webinar is being recorded, that those interviews that are done online can be recorded for future reference in court.
Thank you, DA O'Malley. DA Boston, in terms of balancing the public health issues with public safety and victim safety issues, let me ask you some questions about how you develop an approach or general approaches to bail and bond issues. Bail and bond, it's usually utilized by prosecutors as a tool to make sure our offenders appear in court. And also, especially in crimes of domestic violence and sexual violence, to mitigate opportunities for witness intimidation and tampering and things of that nature. So how have you balanced or approached bail bond issues with those two issues in mind, balancing the public safety and victim safety with the public health issues and risks we alluded to earlier about prison overpopulation or increase in prison population?
Well, what I can say is that we've been working in collaboration with all of our justice partners to address this very issue. And you will see that some of the processes that we have put into place have been as a result to do just this very issue, which is keeping our community safe, but understanding that while we are in this COVID-19 crisis, that the prison population is at a risk, given that their ability to physically distance is not as easy as those of us that are being asked to stay home. And we also want to make sure we protect the public and the workers that are coming into contact with those people as well. So some of the things that we've done in our jurisdiction, specifically around misdemeanors, our chief judge signed a standing order on all new arrests, that with misdemeanor cases, you'll see that we have a signature on release with the exception of stalking and family violence battery cases. And those cases must be reviewed by a magistrate court judge. And those judges are seeing those defendants within 24 hours of their arrest. But initially, the thought process is removing nonviolent offenders from the jail system in order to keep the population down, but also understanding that our individual magistrate court judges need the opportunity to review those cases that do involve violence, and especially intimate partner violence. Our felony cases, we are conducting those first appearance hearings 6 days a week, as we did before. But what you're also seeing is a reminder that our defense counsel is working with our assistant district attorneys to consent on bonds where it is necessary and where it's appropriate. Again, every case is really being looked at as fact specific and not generalizing, but also making sure that we are keeping communities' safety at the top of our priority list. While we are in this COVID-19 times, all of our victim contact is still happening. We are still adhering to the Victims' Bill of Rights in our jurisdiction. We are still safety planning. We are still taking victim impact statements. We are still making victim notification. And all of our hearings, which are being done remotely, victims are being given an opportunity to appear remotely if they would like to, or in the alternative, giving a written statement to be read to the judges. So again, judges are hearing from our victims, which we think is one of the crucial factors in making sure that our community is safe. And finally, we will oppose bond or bond reductions in cases where we feel the defendant is a danger to the public, victim, or will intimidate witnesses on the outside. Just like we look at all the factors of the case, defendant's criminal history, their likeliness to return to court once we are up and running. All of those factors become important in balancing the need to incarcerate pending court, and also making sure that we're protecting individual victims and the community if we feel that a defendant is a danger to society.
Thank you all for your responses. We are now going to transition to our next topic, and I am going to transition to my colleague, Patty Powers.
Thank you very much, John. We're now going to continue our discussion and address some core concerns with the COVID impact on investigation and prosecution, specifically delay that's become involved for all of us as service professionals. I note from the participant poll that 67% of the participants have indicated a concern with the impact of delay on investigation and charging. So what the panelists are now going to be discussing are going to be speedy trial issues and whether or not these are impacting their consideration of cases, and whether they've been able to be proactive in dealing with speedy trial issues that are expected in the future, how to establish due diligence with minimal resources. It's also important that we're going to discuss how to engage victims and witnesses. And even though there's going to be considerable delay in cases, recognizing the impact of trauma on victims of the violent crimes that we're discussing. Also, we'll be talking about making the record, a record that is going to be strong in future litigation to show why discovery may not be available, and also why forensic testing may not be immediately available given the pandemic crisis. So we'll turn first of all to District Attorney O'Malley, and would like to ask you about legal issues that perhaps you've seen develop, or what you've done to try to preempt issues relating to speedy trial. And if you could also talk about how your jurisdiction has managed logistical issues with victims and witnesses, or perhaps to ensure that jury panels remain available.
Yes. So there's been a flurry of activity in the last 2 weeks by the Judicial Council and the Chief Justice of the Supreme Court. And one of the things that we did from the California District Attorney Association, I happen to be the president right now, wrote a letter to the Chief Justice on behalf of the DAs to outline the public health crisis that is existing by having court business be as usual. That we were having defendants who are in custody brought on close proximity on buses, held in holding facilities in the court, defense attorneys too close to them, and then trying to come over and speak to the prosecutor, all the things that we all know, and are urging the presiding judges of all the counties, as well as the Chief Justice, to make extraordinary decisions about changing our process. And oh my gosh, sorry, I was muted. Let me go really quickly over what I just said. That there's been a flurry of activity about how courts are processing in California. On behalf of the California District Attorneys, I'm the president this year. I wrote a letter to the Chief Justice, really outlining what it looks like to be in a courtroom today, when it was still looking like business as usual, with too many defendants, too many defense attorneys, close proximity. It was just it flies in the face of every health recommendation there is. That was the first letter. The second letter, we've got very specific on the use of technology. And our letter included a letter brief, which outlined the legality of using technology, remote testimony, having the defendant remain wherever he is incarcerated, and being able to participate through technology. I sent the letter both to the Chief Justice as well as the governor, and much to our surprise, the governor the next day gave sweeping authority to the Chief Justice to set up new rules in the time of the COVID-19. And the governor went so far as to say that if there are any existing statutes that conflicted with the Chief Justice's new rules, that the statutes would be suspended for 90 days after the lifting of the state of emergency order. So the Chief Justice has made some dramatic changes for that allows all of us to not only use technology, but also to get witness testimony through technology. The most recent order by the chief is that the defendant still has the right to decide whether he will participate in the courtroom or participate remotely. And while we were objecting to that, because as we pointed out to the Chief Justice, is that for preliminary hearing, for a probable cause hearing, that's not a constitutional right. It is actually a statutorily created right. But we went on to cite to support our proposition that witnesses should be able to testify remotely. We cited cases, and specifically Maryland versus Craig, the U.S. Supreme Court case that allowed a child to testify remotely. And the court ruled that in that case, the defendant's constitutional rights were not violated by the use of remote technology to have witnesses present. So our witnesses now can present remotely. We now, in the courtroom for the arraignment courts, we're only running 2 courts a week. We've set up a schedule on which cases will be heard in those courts. We have reduced the amount of discovery that we're providing to the defense attorney, particularly the public defender, until they actually become the attorney of record, enough for them to identify whether they have a conflict. The presiding judge has also ruled that while we can all appear remotely and the defendant can be either way, that the judge himself or herself can actually be in their chambers or could even be at home and presiding over these hearings. So we're really tapping into as much technology as we can. We've also, I let the court know as they've been releasing, really mass releasing, and just this last week, the Chief Justice ruled that for anybody that's not charged with a serious or violent felony, with only 2 exceptions, but for anyone that is not charged with those crimes, they are to have no bail imposed. So for all misdemeanors and lower level felonies, and I put that in quotes, that they will be released from custody. But what we have advocated to the court is that they cannot, if there's a identified victim in any one of those cases, that they have to give us enough time to contact the victim to let them know that this individual is going to be released from court or from jail. And so far, the court has worked with us. As you can imagine, it's an arduous task to do. But again, we have all hands on deck, from the victim advocate, the lawyers assigned to the cases. So we're making these phone calls to let victims know that the person that committed the crime against them is now going to be out of custody. So those are some of the important advancements that we've made. I was just saying that through our arraignment court, we now do not even appear. We have a computer on our counsel table, and we have set up microphones so that we can hear what's going on in court. And my staff is in their offices, and this is happening all over California. We're advocating to the governor to give money to the justice partners and the courts to improve the use of technology. not just for this period of time, but for the future use. And so far we're advocating for that. But most of the courts, the 58 courts, have now gone to remote arraignment, some remote preliminary hearings, and even taking pleas, guilty pleas remotely. It's not business as usual for sure, but we're identifying several ways to get around the requirement that everybody be in a courtroom, and also to uphold the defendant's constitutional and statutory.
Thank you so much, District Attorney O'Malley, for all of the great examples that you gave us and really demonstrating what the impact of the pandemic is on the courtroom, as well as all of the work that's being done by service professionals. So we'll turn now to District Attorney Boston. And we have a number of issues of great importance, and would like to hear from you about how your community may have utilized technology, including closed circuit cameras or teleconferencing, and how you're responding to cases being delayed and the challenge that comes along with that in trying to maintain victim and witness involvement, and frankly, even how to engage in that kind of communication given the pandemic.
Absolutely. So technology has been critical in the way that we're doing operations in DeKalb County. And our Supreme Court Chief Justice declared a statewide judicial emergency on March 14th. And so it immediately allowed for and specifically advocated for video conferencing where possible, and for jurisdictions to find a way to limit the risk of exposure. And so in DeKalb County, we were ready to jump into a remote world. So all essential and non-essential hearings in my jurisdiction are being held via Zoom and are 100% remote. And some of our judges are even live streaming on Facebook and other platforms to comply with or to make these hearings as accessible to the public as possible. But this couldn't have happened really overnight. And I will tell you, when I look at the state of Georgia, our county is the only county currently that is operating 100% remote. I hear from other jurisdictions across the state that are still having to do some form of their hearings in which they are requiring people to be in the courthouse or in a courtroom. And that is just not the case of what we've been able to accomplish in DeKalb. And that really came with us being very collaborative with all of our partners. That is the effort of our judges, our clerk, our public defender's office, and my office, as all of us are working 100% remote. As far as how we've utilized technology, additionally, besides court, I would say that operating my office, the DA's office, so many people have called me to say, how are you running an entire district attorney's office with every single person working remotely? And we have no one, not a single employee operating inside our office. Well, what I'll tell you is that we started doing that on March the 16th. And we have we instituted our remote operations plan the moment the order was signed. Our teams are meeting weekly via Zoom. We have work logs to track productivity. We have a duty attorney, a duty advocate, and a duty investigator every day assigned to address the needs of the public, who can reach us via phone and via email. And we also have duty supervising attorneys and investigators daily, who are assigned to be the problem solvers of the day if any of those issues need to be resolved. We are utilizing 100% teleconferencing to sign search warrants between all of our law enforcement agencies and our judges. And our clerk's office went remote, 100% remote 1 week after we did, after unfortunately we had a COVID diagnosis and a death in our clerk's office, which prompted our clerk to make the very difficult decision to say, I'm not going to have anybody in the courthouse. And so all the public is able to file documents electronically. We were already set up that way, but our clerk also decided during this COVID time that normally the outside public and private attorneys would have to pay to use the electronic service instead of coming to the courthouse, but she has made that open and available as a free service, since it is required that any filings, both civil and criminal, within our courthouse must be filed electronically. My exec team meets via Zoom every Friday, and we hold an office-wide supervisors meeting every Monday morning, also via Zoom. So we have embraced the use of technology, not just for how we are running our court hearings, but we have also embraced the technology to run our offices so that we can be physically distant and continue to protect all the employees that work in our courthouse every day. As far as delays and increased challenges in making direct connections, we are, as I said, still making victim contact in all of our cases as we would prior to the emergency order, and we do that at our first appearance hearings. Because we are working remotely, all of our case files are being opened remotely and electronically. We decided the physical files could be created when we got back to normal, but we can create our files remotely, which means that our victim advocates and investigators are making those initial contacts. And all of this is to prevent that issue later on, meaning if we haven't been in contact with our victims during this time, a fear that we may lose that information that we get that's so crucial and critical in the beginning of our interactions. We have victims and witnesses that are contacting us because they expected to come to court or they expected a case to be tried. So we are continuing to update victims and witnesses on the status of cases and continuing to let them know that or keep them as informed as we can about the status of those cases. And of course, our victims are able to use Zoom to appear at any hearings that are happening at this time in court. And we're making sure that those people that need to be at those hearings have the opportunity to be present if they would like to. And I think for us, the best way for us to minimize attrition moving forward is just doing this early legwork. I think will ensure that once we are back, we can circle back with those victims and witnesses. But the fact that they're hearing from us during this crisis is important to develop that initial rapport and address those immediate issues that they have.
Thank you, District Attorney Boston, for all of the practical suggestions that you're offering as well, based upon the commitment that we all bring to victims and wanting to do our best possible work to secure their rights. I'm turning now to First Assistant McCann. We've been focusing a lot on the delay occasioned by the pandemic, the challenges in direct communication in a current era of social distancing. Could you describe for us the strategies that you've developed to keep victims and witnesses engaged and minimize case attrition? And we're also receiving inquiry from advocates who are also participants today about the role of advocacy and what the potential is for making advocates available to victims in a remote type setting.
Okay, I just start with That's a really good question that's being asked by the audience. I'll get to that in 1 second. But DA Boston's last point is an excellent point. You talked about early legwork. In some ways, strangely, I think, because everyone's working remotely in our office too. Everyone has access to each other in all the ways that DA Boston just described in our office as well. But in some ways, I think because the DAs aren't dealing with the day-to-day pressures of what happens in court and things of that nature, that victims are getting a lot of attention right now. And I'll talk about this at the end when we talk about how to deal with, the backlogs and bottlenecks to come. But I really feel like the level of preparation for these types of cases should be at its best right now. That the victims should be receiving more contact, if anything, than they were receiving before, given the fact that the day-to-day pressures are not there. People have a chance to actually prepare more. They should have that chance in any event. The question about the advocacy, I think it's a really, really good question. We have a great partnership with our domestic violence agency in Montgomery County, as I said, Laurel House, and we have enlisted them in everything in terms of this process, and also our victim services people. And that means Laurel House has had to sort of on the fly adapt. As I said, they're using FaceTime to help victims as they're going through the protection from abuse process. There are still domestic violence victims going to the shelter and being sheltered. I think that Laurel House is doing a really good job of outreach in terms of their social media and trying to get the word out that there's a place for people to go. And we are enlisting victim advocates to help us in any way we can in terms of notification of victims about things that are happening. So I'm going to get to that now. We have been, as DA Boston said, in their jurisdiction, we're doing the same thing. We're adhering to the Victims' Bill of Rights and notifying our victims at every opportunity that we can. The problem that can result, though, is when there are mass releases. We had one of those happen in our county, and that is the president judge ordered that anybody who was in custody on work release was going to be furloughed and released into the public. And we had a case that was a pretty serious domestic violence, sexual assault case that there was no notification made. So those of you that are dealing with that mass release issue, you might really want to focus on victim notification. If you can. I mean, if you get advance notice, that's something that we had one case slip through the cracks. Our victim and her family were very upset, rightfully so. One of them said, he won again, which is something you never want to hear one of your victims say. It's heartbreaking when that kind of stuff happens. So the notification part of this is so important. And that was a situation where the president judge put this order out and the defendants were out of the jail before we even had a chance to say anything to anybody. And I know some of you are dealing with similar problems in terms of these sort of blanket orders that are being issued. Luckily, for the most part, our county has gone through these release procedures on a case-by-case type of basis, so we haven't had that problem again. And on cases where we think somebody's going to be released, or even if we know that there's going to be a question about a bond reduction or things of that nature, we've been able to get in contact with the victims ahead of time and get their feelings on it. We are doing these hearings. Actually, the bond reduction hearings are being done teleconferencing. They're not being done in a courtroom, but we at least have the benefit of the victim's thoughts and wishes before a decision is made. And we've had that happen on some threats and stalking cases, and even on misdemeanor assault cases. We're getting victim input on those types of decisions. The Department of Corrections is going to start releasing people in Commonwealth of Pennsylvania starting next week, but they have provided us a list. Fortunately, we have until Monday to give our input on that. We have about 24 cases that we have to go through. We can object, but that won't be dispositive, but at least we'll have the opportunity to notify victims on cases where there are victims, and obviously enlist advocates for that purpose, and also for safety planning purposes as well, if one of those defendants is going to be released. So I feel like at this time, the pandemic is obviously a terrible thing in so many ways, but it does give us the opportunity to keep our victims informed. I think maybe even better than we were informing them when the court system was operating, quote, normally.
Thank you so much, First Assistant McCann, for emphasizing a victim-centered approach to prosecution. It's critical to all of us that have the privilege of serving victims and communities.
And I was not unmuted. Sorry. We've been tracking a lot of the questions that have appearing in the Q&A, and they are so many good questions. Unfortunately, we won't have time to address all of them. I did see one reference or request about the letter brief that DA O'Malley mentioned that is publicly available, and we'll be sure to forward that. I also saw a request from DA Boston to get a write-up of that remote plan, and we'll talk about how to follow up on that well. But we do want to address our last topic, which in of itself we think could comprise an entire webinar panel, but in so much as we're able, we want to get each of our panelists' perspective on the issue of what happens when things get back to normal, or maybe more accurately, when we get back to a new normal. And specifically with the delay and reduced availability of courts, there are backlogs developing, and these cases and new cases will happen when courts are fully reopened. So as administrators and as policymakers, how do you deal with the backlogs and bottlenecks that are going to happen when the courts are fully reopened? And the other challenge too, at least from a planning perspective, is how do you develop an adaptable plan when to date no one has any clear idea of what the end date is, or how long the measures currently in place will have to continue. So what I'm going to do, I want to be sure to hear from the panelists on this issue. So I'm going to first turn this question over to First Assistant McCann and see if he can talk a little bit about the approach being considered in Montgomery County.
So this is the fourth week that we've been dealing with this in terms of our county since the emergency order has been declared in Montgomery County, and pretty much since the beginning, the District Attorney Kevin Steele has talked about this issue that's going to face us, as you said, John, when we get back to whatever the new normal will be. So we have weekly executive meetings, and the leadership of the office is also meeting with each other constantly, remotely, obviously, about these topics. So one of the things that we're doing is making sure that the DAs know that when things get back to the new normal, that they have to be as prepared as they possibly can on everything. DA O'Malley said that in the call we had yesterday in preparation for this webinar, and I couldn't agree with anything anybody said more, and that is that this should be a time period where you're going to be super prepared when we get back to some semblance of normal. Some of the other things we did, we got our court to agree to, even though we only have the one emergency courtroom for criminal, we got our court to agree to take guilty pleas on cases where defendants are in custody and they'll be eligible for parole after the plea. So, and we're constantly looking to see if there are cases that could be resolved fairly in that fashion. So we're doing guilty pleas remotely. There's a video conferencing system in the courtroom that we have, and so the public defender's office, who does most of these guilty pleas, of course, has not objected to that procedure, and then we've been constantly looking for those types of cases, so to reduce as much as we can that backlog. And then again, the unit chiefs in our office have asked the DAs to sort of prepare a list of cases that won't be heard on an emergency basis, but could potentially be resolved with guilty pleas when we return. And they're working on that list now. So we'll have a bunch of pleas ready to go when the court's ready to get back to some normal schedule again. They have the capability of obtaining and reviewing discovery remotely. So they should be providing it now too, so that we shouldn't be having any issues of discovery not being provided and having delays in cases when we get back, however long that takes. We have also begun reviewing cases for our biggest diversion program, which is called ARD in Pennsylvania, but it's basically first-time offenders, mostly first-time offenders, non-violent offenders. We're taking these applications now, and they will be ready for approval en masse when we get back to a regular court operations. Not as many cases obviously are coming in now. There's been a significant reduction, so I feel like we'll be as ready as we can be when things open up, because everybody's doing so much work on the, as DA Boston said, on the front end right now. The thing that bothers me or troubles me or concerns me, I guess, the most is what's the realistic timetable for having jury trials? Because obviously when you have a jury trial, you have a bunch of people that come in, whatever the size of your jurisdiction. You know, typically in Montgomery County, we might have 100 people come in on a particular day. I mean, I know that in larger jurisdictions, it's far more than that. But we may have 100 people, and they're going to be on top of each other in the jury assembly room. And then when they're being subjected to voir dire, they're going to be on top of themselves, and you can't really find room to be 6 feet away from people when you have a jury box. So when are we going to be able to do that? Because even if you get as prepared as you can be on everything, and the things that can be resolved fairly by guilty plea or bench trial can all be prepared. But what can you do when you have to have a jury trial, when it's a serious sexual assault or a serious domestic violence case or a murder case? I mean, those cases typically are not resolved short of jury trials in Montgomery County. And I think that's the biggest unanswered question. And I really don't know what that's going to look like. And I think that's probably what my biggest concern is as to whatever this new normal is going to be.
Thank you, First Assistant McCann. DA Boston, I know you were raising some of the same issues or concerns during our preparation call yesterday. Can you talk a little bit about how you're preparing or planning for the new normal in DeKalb?
Absolutely. So I'm going to echo a lot of what First Assistant McCann said about returning to the new normal. But I start with a proposition that I started earlier, is that everyone, if you haven't done a remote operations plan, it's not too late, because it seems like many of us are preparing to be sheltered for another 4 weeks or so. And it should lay out your, as I stated, your current operations plans and expectations while working remotely. So turning from there, of course, if you've heard or figured out anything about me, if I think you should have a remote operations plan, you should also have what I call a return to new normal plan, which is what we are already working on, despite the fact that we have a judicial state of emergency right now that's been extended through May 13th. So we have another month, but we're working on that now. So when you ask yourself, how can you return to the new normal? You have to first determine who should be in your working group. We are now determining who from our office needs to be represented in our working group to think about, forecast, and come up with a list of issues that we should be thinking about. And you want to make sure you have a good, diverse cross-section of your office of people that do various things, so that they can begin to think about all the different aspects of running not only the court system, but your office. Create a list of items that include not just the legal work. I mean, the legal work is a big part of it, but operating your office and the courthouse under what we believe will be ongoing CDC recommendations. And just like First Assistant McCann pointed out, I've been starting to brainstorm with, how do we conduct jury trials? How do we put 12 people plus an alternate or two in a jury box, where in our jurisdiction, the chairs, which are bolted into the courthouse seating, are about 1 feet apart from each other at best, which is certainly not within the physical distancing that we all believe we're going to have to continue to maintain. So we're starting to talk about what suggestions do we want to make to our judges about these processes. Connect with your stakeholders and partners within your criminal system to collaborate on operations. So your clerks, your chief judge, your sheriff, all the people involved in the system need to understand the dynamics and what changes need to happen. In our jurisdiction on Mondays, when juries are usually called in, usually we summon about 400 people who wait in one room. And that room is comfortable, but under our new guidelines, we won't be able to do that. So it may mean that we're going to have to talk to court operations about reducing the number of people that are asked for jury duty, or staggering the times that they come in. And I will tell you that will significantly slow down the process that our judges are used to, because they're all ready to start at the same time and want their panels brought up. And that just won't be able to happen. Think about how much time you need to ramp back up for significant motions, hearings, or trials. Is it 2 weeks? Is it 4 weeks? Is it 6 weeks? You need to examine what you would need to do to ramp up for getting witnesses back into court, for locating witnesses, travel, and if you're going to be able to get out-of-state folks in the way that you did before. Think about your day one. How do you reopen the doors to your office? If your emergency order ends on May 13th, how do you plan to walk back in the next day? Meaning, are you going to have all of your staff immediately report? These are things that we're starting to think about. Finally, you have to plan for your second wave and look for ways to flatten that curve. I'm certainly not a doctor, and Dr. Fauci is amazing, but he has been talking about the fact that we do have to plan for a second wave. And if we're not talking about that in our court system and operations plan, then we're doing a disservice. The last thing we want to do is bring everybody back to a courthouse only for there to be an outbreak within that courthouse community, which means it will have to all be shut down again. Your new normal operations plan should contemplate through the end of 2020, meaning don't just think about week one back or day one back. You should be writing a plan that contemplates how you can slowly return to normal and the effects that COVID-19 will have on operations all the way through the end of 2020.
DA Boston, thank you for such an informed answer. And I know we're running a bit late, folks, but this information is so great. I want to be sure we hear from DA O'Malley a little bit about what sort of plans and contingencies are being prepared in Alameda County.
Well, I echo what both DA Boston and Chief Deputy McCann have said. I mean, it's amazing to me that we are across the country from each other, and yet the things that we are confronting and the issues that we are addressing are very, very similar. And the responses that we've created are very similar as well. So I will add my contribution to this. But first of all, there was a question that I just want to address, and that came from, I think, from Angela, and I may pronounce your last name wrong, but it's Povolatis. And her question was, how do you keep victims and witnesses engaged when these delays in trials are happening? And the answer is, for us, is that we are keeping in contact, a lot of contact with victims and witnesses. We're doing it through our Family Justice Center. We're doing it through our victim advocates. We're having our lawyers. So we're not stalking them, but we are making sure that they know what's going on, why there are delays, and if they have any needs, we're here to address them. In terms of the plans that we're making, we're a bit fortunate that the Chief Justice's orders are in place for 90 days after the state of emergency is lifted. So it's, for us, the business as usual. Well, for none of us will it be immediate, but for us, there'll be another 90 days after we're starting to come back into place. Though I cannot agree more with DA Boston's comment that going back to normal cannot be, we've lifted the state of emergency, the shelter in place is now lifted, let's everybody come back into a crowded room. So some of the things that we're looking at right now is how we're going to deal with the tsunami of cases that we believe are happening. Just as Assistant McCann said, we're putting fewer cases in the system, but we had a lot of cases before this came up. And most of those people are going to be out of custody. So part of our effort is how are we going to get people that are out of custody to come back into court, knowing that when they come back into court and they have a trial, they could very well be convicted and go to jail. So we're anticipating we're going to have a lot of people not show up for court. We are anticipating, we're prioritizing for us the cases that we need to pay attention to. And just as is happening across the country, every one of the lawyers, every one of the investigators and advocates are preparing all cases they have right now. So when we start moving back into something that looks more normal, we will not have a backlog of cases that need to be prepared. We've actually been sending cases across the different teams. So if one team has
DA O'Malley, I think we lost you again.
Sorry, where did you lose me?
You're sending teams or DA teams across the county, as I believe what I heard.
Yes, so we're spreading the cases across all of the teams so that there is we don't have one or two teams that are overloaded with the busy cases, to be able to have all cases ready to go when it's time. The other thing that we're doing is, just like the other speakers have said, is that we are preparing for what will happen through 2020. And that's a critical plan, because I really don't think, after we've had this experience, that we are really going to go back to what it looked like 6 months ago. I think that technology has made its preview here, that we'll be working in different venues. With respect to jury trials, that we have actually been talking and looking for space that we can take over as a makeshift courtroom, so that we can allow jurors to sit 6 feet apart to be able to still participate in the trial. So we're really looking at all of these different options that we have, short of bringing people into court. I will point out too that for many of the people that are many of the defendants, they don't particularly want to be in court either, and so we're really looking at how far we can take this use of technology through, especially the probable cause hearings, not the jury trials. We've already been setting our cases out through the summer, so we're trying to be proactive in not having every case come back as soon as this is lifted. And by doing that, that we will spread it out over the several months. The issue of preparing motions in advance, we are anticipating that the defense will take the opportunity to try to jam up the system. By that, they can be filing speedy trial motions or removing their time waivers, so that we have a number of cases that actually have to go to trial within 60 days. And in anticipating that, we're creating a brief bank of motions to respond to those, what we're anticipating will be those types of motions, to really put the court at a disadvantage of being able to have enough judges to do the trials that are going to be coming up. We're staying in touch with the crime labs to make sure, as I said earlier, they're testing. And what's critically important also is that we're using every opportunity we have to be able to do more investigation on the cases. This is actually one of the positive parts of the cases not going right away, is that it gives us more time than getting a case from the law enforcement, having to file charges and then go right into court with the cases. So it's helping us to prepare more thoroughly these cases, and then evaluating which cases we're able to resolve, perhaps even for less than we did in normal times, but resolve so that we don't jam up the case with the less serious cases while we have very serious cases that are pending. And then the last thing is that we're just reassuring the victim survivors that, and continuing to let them know what the resources are that are available to them. And I think that's a critical part of our planning, is we're not just on hold from now until whenever this ends, and whenever we get past the next surge, but we are in this for the long haul. And we want to make sure that when victims need something from us, or if they have questions, or if they're feeling anxious, that we are there and available to them, so that when it does come time to call them to come back into court, if that's 6 months, a year away, that they understand why there's been this delay and they're still ready to come into court and testify about the crimes. The key, I will say, ending this, is what is really critical for us is not to deal cases cheaper than we might otherwise, those serious and violent cases, because of pressure or other things. You know, there's serious violent people that are out there that have hurt other people, and we have to maintain our integrity while trying to balance all of the other issues that are going on, including releasing people that are not dangerous to the community.
DA O'Malley, thank you so much for that answer. Before we wrap up, we have our second participant poll, and let me just, before we submit this participant poll, let me let everyone know who's attending or virtually attending today that this COVID-19 panel discussion, it's not going to be the end of the conversation or training and technical assistance available on this issue. Rather, we're looking at the beginning, but to help shape future training and to help OVW decide what training to support. We want to find out from our audience what kind of subjects or matters you would like to see covered. Unfortunately, the nature of the technology is it's a multiple choice question rather than an open-ended question. But the question we have for you is, what topics would you like to see covered regarding COVID-19's impact on sexual violence, intimate partner violence, stalking, human trafficking, and other violent crimes? And your choices are A, how to keep victims involved in investigation and prosecution. B, protecting the record regarding delays caused by COVID-19. C, ensuring a multidisciplinary response for victims of violent crime. Or D, balancing bail bond reductions and early release with victim safety. I think, as you can tell, with a little bit of the time pressures during this presentation, either one of these subjects which we addressed in this presentation could easily take up an entire conversation of themselves, and probably will, but in order to prioritize, your input is much appreciated. And I'm going to wait for Holly Furman to give me a cue before I wrap up.
John, I think you can wrap up. Are you able to see the results to the poll?
I am not.
Okay, so we had a lot of responses and people are still responding, but it seems like the answers are all pretty evenly divided. Most people would like to see a webinar about balancing bail and bond reductions and early release with victim safety, but all of the options are of interest to our participants.
Oh, very good. Well, thank you for your input. I first want to give the contact information for my colleague, Patty Powers, which is right here, and also for myself, which is right here. And AEquitas exists to help folks in the field and prosecutors. So any sort of assistance you need, please reach out to us, and we're going to work as best we are able to help you or to put you in touch with people that can. And I'm going to give Patty the last word, but I want to begin by thanking our panelists today. First Assistant McCann, DA Boston, and DA O'Malley. They are leaders in their community and leaders in the field of prosecution, and I know time for them is a finite resource. So words cannot express our gratitude for the time the three of you have given to this project and to helping your colleagues, most of whom you're not even seeing. but your experience, your leadership, and your dedication to service it's wonderful to behold, and much appreciated to listen to. Thank you to all three of you. Myself and my colleagues at AEquitas are eternally grateful.
I want to thank our amazing prosecutor panel also for your leadership in your communities and nationally, and also for the insight that you shared with all of us today. I also want to thank all of the participants who have been able to be with us for the work that you do every day to secure victims' rights and to advance community protection in this era of the pandemic. Thank you very much, everyone.
And I'll just one final note to wrap up on. We will be following up with the recording of this webinar, as well as an evaluation and answers to the questions that we were not able to get to during today's panel. Thank you, everybody.